Good morning, everyone. Welcome to Cornell Cooperative Extension and our monthly consumer issue program. I'm Mike Danaher. I'm an Assistant Attorney General with the New York State Attorney General's Office. We do monthly consumer issue programs here at Cornell Cooperative Extension. We've been doing it for a really long time, and it deals with many different consumer-related topics throughout the year. Today's program is one that is well received and quite popular. It deals with landlord and tenants' rights and responsibilities. I know that in the Ithaca area, a large percentage of housing is rental property, and therefore it's a very pertinent topic to this particular area. Also, there is a huge change in the laws on landlord and tenants. It was dramatically changed on June 14, 2019. There should be this big day that's commemorating the changes in landlord and tenant laws. Many of the provisions, unlike a lot of law changes, which take place in the future, like 6 months from now or 30 days from now, many of the provisions that were adopted and signed into law by the governor on June 14, 2019 took effect immediately. So they are, most of them are in place now. I'm not going to go through and say, okay, that's in place now and that's not. Let's just go with the assumption that it's in place now and go from there. They are extensive changes. I won't be able to touch on every single one, some of which don't even apply in, for lack of a better term, upstate New York. Some of it deals with changes to New York City's administrative code. And New York City has rent controls that were completely changed around with this. But just to show you the extensiveness of the changes, here is a copy of all the changes that were made on June 14th. It is 74 pages of laws that were changed or added to. It's broken into 15 different parts, dealing with evictions or other topics. So it is extensive. And the changes are major. And it's very important for people to understand what their rights and responsibilities are. And I would say, in particular, landlords need to be very, very aware of what this is. And I'll give one example that I'll touch on in more particulars later, but that is in the case of evictions. Because if a landlord does not do everything by the letter of the law, I's dotted, T's crossed, they will find that they are stuck having to start over again. And because the time periods in eviction have vastly expanded from what they were previously, you could be 2 months behind if you make a mistake. So it's very important to understand what the rights are. Consequently, also, on the other side, the tenants need to know what their rights are. The laws have been changed to give further protections to the tenants. It's Tenant Security Act of 2019 or a name similar to that. And the reason why I say a name similar to that is each section may have a different name change. I told you there are 15 different sections, so there are different titles to what they are. But parties need to know what their rights are and also, importantly, what their responsibilities are. Let's kind of just start out generally without the particular changes. Let's talk about in general. What is a lease? A lease is merely a contract between a landlord and a tenant to give up or receive exclusive use and occupancy of a particular piece of property. In this case, we're primarily going to talk about residential property. Some of the provisions apply in whole to all types of leases, but we're going to focus here, because it's a consumer issue program, we're going to focus on the residential relationship. Just as a preface, the lease, a lot of people would refer to as the written agreement between the two parties. So I'll ask consumers, sometimes tenants, when they call me, I'll say, what type of lease do you have? And they say, well, I don't have a lease. Well, technically under the law, you have a lease if there's an agreement. But leases do not have to be in writing unless, and there's so many caveats to this, I hope I question myself when I talk in universal terms, but it generally doesn't have to be in writing unless it's for a lease that's longer than a year. Again, most residential leases are a year or less, but if it's a 2-year lease or whatever, then you'd have to have it in writing to be enforceable. That's a whole separate law. It's called the statute of frauds, which contracts that can't be completed within more than a year, then they have to be in writing to be enforceable. But generally speaking, it doesn't have to be in a landlord-tenant situation, except in one situation, and I'm not going to spend a lot of time on this today, but manufactured home parks, the landlord must offer the tenant a 1-year lease. Now, if the tenant chooses not to accept it, that's another thing. But they must offer a written lease of up to a year. But generally speaking, the typical landlord-tenant situation does not have to be in writing to be enforceable. And now disregard everything I just said, because I don't believe that it is anyone's best interest, the tenant's interest or the landlord's interest, to do anything but put it in writing. It solves so many problems if you put it in writing. Every term that you could possibly think of related to the lease really behooves everyone's interest. Put it in writing. Even if the lease is a month-to-month lease, you can still put it in writing. You just put for the term that it's month-to-month. I will say that absent any other agreement between the parties, the law presumes that it's month-to-month. So if you want it other than that, you need to agree to it specifically. You could agree orally to a 6-month lease. It's binding on both parties, but how do you prove it? It's so much easier. Just put it in writing. Get it in writing. It answers a lot of questions, because then if the tenant says something like, well, who is responsible for the water bill? Put it in writing. So then, I wasn't supposed to pay for that, the water bill. Well, here's our lease, and on paragraph 13, it says tenant responsible for the water bill, or utilities, or whether their pets are allowed or not. Just put everything in writing. It solves so many problems. So that's kind of it in a broad network. What we're talking about is an agreement between two sides that is a contract, governed by general contract principles of law, which, not to get into too much of the weeds of the law, but there's generally two types of laws. One is called the common law, and one is called statutory law. The statutory law are the laws the legislature enacts and put in the law books, and you can pick it up and read. And all these changes we're going to talk about today are all statutory. They're all based on a statute that the legislature adopted and then the governor signed. Common law is just kind of what's evolved over the years in decisions made by courts and that sort of thing. We're primarily dealing with statutory laws that have gone into place, but there is there's always been a general principle out there of and not codified in a lot of respects, but now, especially in the area of manufactured homes, there actually is a statute dealing with the warranty of habitability. But under the common law, there was always a warranty of habitability. There's a warranty attached to every lease, whether anybody puts it down or not, that it's habitable. The residence is livable. What does that mean? It's undefined. But it's a minimum standard. It's not that there's air conditioning. It's not that you have the Taj Mahal. It's a base level that it must be livable. So the landlord has the obligation to furnish to the tenant a habitable residence, a livable residence. What are some of the basic things that I think in 99% of the case, maybe 95% of the cases, we could all agree what's a habitability issue and what's not? I generally, it's not black and white, but it's generally code kind of issues, things that really deals with the health and safety of people in the residence. Do you have heat? Do you have hot water? Is the roof over the head a roof? Can someone live in this place? That's a requirement. Other than that, there's no other restrictions imposed. It must be livable. Let's talk about this livable residence and what changes have been made as of June of 2019. There are new tenants' rights that are out there. They're general. The first thing that I want to impress upon landlords is no landlord can refuse to rent to a potential tenant because the tenant was previously involved in a prior eviction proceeding. You may not use that against a prospective tenant. What's that mean? It means there's a rebuttable presumption of a violation if the landlord has requested information from a tenant screening bureau or otherwise inspected court records and thereafter refuses to rent to a tenant. And landlord may sit there and say, oh my goodness, this person was just evicted because they didn't pay their rent. You may not use that against them in deciding whether or not to rent to them. That's what the law says. And they said it's a rebuttable presumption that if you've undertaken these actions and said, okay, I'm not renting to this person because they were involved in a prior eviction proceeding, that it is a violation of law that can subject you to not only an injunction action by my office, the statute specifically says the Attorney General can enforce, but a civil penalty of at least $500 and not more than $1,000. So you could be whacked for up to $1,000 for refusing to rent to a tenant under these particular circumstances. I have no opinion one way or the other, if fair, unfair, whatever. I sit here and say, this is what the law says. This is what it says. And we are bound by what the law says. So that's the first thing. Big, big change. No application fees may be charged against a prospective tenant except for a background or credit check. And the only charge that can be imposed is the lesser of the actual charge that the landlord incurs in getting that check, credit check or background check, but no more than $20. So if the background check you paid for cost $50, you can only charge $20. That's what the law says. There can be no fee charged if the tenant provides a credit check or a background check that is no older than 30 days. So if the tenant actually had gone out and gotten their own and hand the copy over to the landlord cannot charge an application fee or a credit check fee. Another big change. Landlords may not charge late fees for the payment of rent unless the rent has been outstanding for 5 days or more. Not sure if it's more than 5 days or 5 days or more, but 5 days. So if on the third day, the rent's due on the first of the month, that's a classic example we'll use. Hasn't been paid on the first day, it's now the third day, hasn't been paid, and the tenant comes in and hands the money, no late fees may be charged. And interestingly here is, if there's a provision in the lease that says, I don't care what the law says, payments due on the first, you agree that any payment not paid on the first, there's a late fee, it is void. The law says you may not do this. Here's another thing. Late fees. Late fees can be no more than the lesser of 5% of the outstanding rent due or $50. Again, whichever is less. So if the rent is $500 a month, the late fee can be no more than $25. And there is no compounding, meaning you can't charge them $25 every month. You can charge them if they're late the second month for that second month, but you can't tack on anything for missing the first month. It'd be the $25. So it's the lesser of 5% or $50, whichever is less. And again, there is no allowance for agreeing to a different amount. It is void if it's different than that. So very important. Now, landlords must also keep written receipts, or must give written receipts for rent paid by cash or any other method other than a personal check. So if the tenant gives their own personal check, of course, that'll be their receipt when the check gets canceled. If it's a money order, if it's some other method, bank, cashier's check, cash, the landlord must give a written receipt, and there has to be certain things in it. You know, how much it is, what it's for, who paid it, all that stuff. And they must maintain records. The landlord must maintain rent receipt records for 3 years. So now the law, it didn't before, but now the law is imposing on the landlords records, written records of everything that was paid. Because, you know, tenants will get a written receipt, and it's those one little things you rip off the book and everything like that, and it disappears. They move out, and it disappears. The imposition of the law is the landlord must maintain records. So landlords, maintain your records. Frankly, landlords, you should be maintaining records anyway. It just makes good business sense to do this anyway. Maybe this should be called the good business sense landlord-tenant laws of 2019. But that's the requirement. Another thing, and this will be, I'll mention a little bit later when we're talking about eviction. If a payment is not received within the 5 days, you know, we say that they've got 5 days to pay and it's day 5 and the landlord hasn't received the payment yet, the law has now imposed a requirement that the landlord must send by certified mail a letter to the tenant saying, you know, you haven't paid the rent and it's due. So if it's not received within 5 days, there is a notice of written by certified mail notice to tenants that the rent has not been received. Here's an interesting point. Put stars up, flags waving. Failure to send the 5-day notice letter may be used as an affirmative defense in the eviction proceeding. So one caveat to landlords out there: you don't do this, it's a defense. All the tenant has to do is come in and say, never sent me the 5-day letter. And you know what that means? Eviction dismissed. And you have to start over. So make sure you do this. Keep a record of it. That's the certified mail thing. Keep a record that this happened. Now, going on to a little caveat of security deposits. Now, not affecting the law or anything like this, the new changes in the law, that is, but security deposits are for the very purpose of security. It has never been determined that security deposits can be used as additional rent. So landlords, there are requirements for you regarding the handling of security deposits. That hasn't changed. And that is that the security deposits must be kept separate from your own funds. It can only be used to cover damage, failure to pay rent, expenses for cleaning up the property, that sort of thing. That's the only way it can be used. It can't be used until after the tenant has moved out and that damages have been verified or amounts owed have been verified. Cannot use it for any other purpose. There are certain rules with a security deposit, and that is that the security deposit, if it is 6 units or more, must be in an interest-bearing bank account. That's, and because there's so much stuff to pack into that, I'm not going to get into a lot of it. It just, the interest belongs to the tenant, except the landlord could have charged a 1% administrative fee, and we all know what bank accounts are paying now, so it's kind of an academic discussion more than anything else, because the landlord can keep anything up to the 1% limit. If the account generates more than 1%, it belongs to the tenant. At the end of the lease, it must be returned. However, there has been changes in the 2019 law, and that is that, first of all, there was never any provision, and I used to talk about this. We do this talk, by the way, twice a year, so I've talked about this a lot, is that there used to be never a rule as to what the security deposit is. It was always considered to be 1 month because that just seemed to be the way that everybody did it. It was so common that frequently people thought that was in the law. It wasn't in the law. There could have been a 2-month security deposit. There could have been whatever. That's no longer the rule. The rule is, the law has been changed, that no deposit shall exceed 1 month's rent. So now we have a statute that says what security deposit amount is, and it's 1 month's rent is the maximum. It must be returned except for outstanding rent that's owed, damages that were caused, moving and storage of a tenant's property because you can't store it there anymore, things like that. It says there can be a deduction for that. There can be no deduction for reasonable wear and tear that has occurred on the property. I think, again, in a large percentage of cases, we can all agree what reasonable wear and tear would be. Holes in walls are not reasonable wear and tear. Carpets that have worn out over a period of time are reasonable wear and tear. Apartments have to be repainted, not due to damage or kids writing on crayon on the walls or anything like that, but periodically it has to be painted over. Now, if it is a customary practice that the landlord paints over after every tenant moves, that's reasonable wear and tear. That's a choice that the landlord has made, that it needs to be done. And we all know, even those of us that have our houses and stuff, we've got to repaint periodically. If it's not due to any damage, it's just a normal thing that the landlord undertakes, cannot be charged to the tenant. So those rules have kind of been the same even under common law, but now statutorily you cannot do that. Here's another thing. Landlords, beware. Beware. This is really, really important. Within 14 days after a lease ends, the landlord must provide to the tenant an itemized statement of any damages that have occurred. 2 weeks you have now. There was no set time before. 2 weeks, 14 days, you must provide to the tenant notice of the damages and return the difference between the deposit and how much the damages were. Must return it. So if the security deposit is $1,000 and there's $500 worth of documented damage to the premises, you can keep $500 to cover the damage. You must return the difference, the $500 difference. Here's another big caveat. Failure to provide the itemized statement within the 14 days, the landlord forfeits his or her right to retain any money. 14 days. You don't do it, I don't care how much damage there is, you don't get to keep it. So make sure you sit by those, follow those. A willful violation, and we leave it up to the courts to decide if it was willful, can result in the landlord being charged up to 2 times the amount of the deposit as a penalty for retaining the money in violation of that statute. Get the itemized statement right away. This could be problematic because it may take some time to get estimates and things, but I'm just telling you, that's what the statute says. Be very careful because a willful failure, a court could award up to 2 times the deposit. So that $1,000 deposit that you received could be a $2,000 penalty going back to the tenant.
I have a question.
Yes.
In the law, is there a statement that the security deposit now has to be returned within 14 days?
Is there a provision in the, and I repeat it so people can hear us out in TV land. Is there a provision in the law that says that if the deposit is not returned within 15 days, that this policy can go into effect? It doesn't say that. It says that within 14 days, the itemized lease, I would say yes, you can infer that, because what it says is that the landlord must provide the itemized statement and return the difference within 14 days. Okay? So that would tell me you got to return it within that period of time. Okay? Again, we're going to, court decisions interpret the statute, and we're going to see how courts end up playing it out as time goes on. Another question.
Yes, so regarding the itemized documentation, I work at Cornell, so I try to always guide my students to ask for receipts and pictures and stuff. When you say itemized, can you give me examples specifically? What should tenants be asking for?
What is the itemized, what does itemized mean? As far as I would say is there has to be an itemized list saying what the damage is and how much it's going to be.
Like an Excel document is acceptable?
An Excel document, I don't know what the courts are going to ultimately say. All it says is an itemized statement. I don't think it necessarily means that you have to put repair receipts with it. You just need an itemized statement of what that amount is going to be. Again, an itemized statement would seem to satisfy what the statute says. More to be decided as time goes on. So So the burden is on the landlord to do this. Landlord should make sure that they go ahead and do that. Okay, next thing. Landlords may not retaliate against a tenant for filing a good faith complaint regarding health or safety violations or for rent gouging. I'm not sure what that term means, other than there will be something that we talk about in a minute. Or actions by tenants to enforce their rights under the lease. So if the tenant attempts to say, hey, my contract provides you're supposed to do this, and you're not doing this, you got to make sure you do that. Or they sue the landlord because the landlord didn't pay a water bill and they had to pay their own bill. Any sorts of those things. A tenant filing a good faith complaint, like to code, for example, or trying to enforce their rights under the agreement, the landlord may not retaliate against the tenant, or in addition, the tenant's participation in a tenant organization. So if there's a tenants' rights group that lives in a complex or something, cannot retaliate against them. And what does retaliation mean? Retaliation means you cannot refuse to renew a lease or offer a new lease, or you end up offering a lease with an unreasonable rent increase. There's that term we talk about frequently here, is unreasonable, reasonable. There's no definition of what the unreasonable rent increase would be, but I think in a lot of instances you and I could agree, increasing the rent double or something like that is pretty unreasonable. You may not do that. You can't refuse to release to somebody because they complain to the code or anything like that. And the landlord can be subject to a civil action as a result of that, including attorney's fees, costs, or any other relief that damage that the tenant may have incurred. It can also serve as an affirmative defense in eviction action. So landlord, I use a scenario. Partway through the lease, tenant complains to code. Code comes in and says, you don't have this, that, the other thing, got to clean it all up. Landlord says, I'm not re-renting to this person. And then tries to terminate the lease and evict the tenant for staying past the end of their term. It is a defense by the tenant to say, this is retaliation because I filed that complaint. It's a rebuttable presumption again. I mean, the landlord is presumed to have acted retaliatory unless they rebut that. The retaliation of the landlord serves, it's a notice of quitting the premises or an eviction proceeding, or substantially changes the lease terms if they do so within 1 year of when the complaint was filed. So if you file the complaint 6 months into a year lease, there's a presumption that if the landlord chooses not to renew, the landlord can rebut that presumption. They can say they have some other reason for it, but it's presumed that it's retaliatory. So landlords must offer a new lease unless they can show some other reason. The landlord has the burden of proof, and oftentimes court case comes down to who has the burden of proof. If it's a burden of proof and the tenant comes in and says, the person's retaliating against me, I filed a complaint a couple of months ago, all of a sudden they're not going to renew my lease. The landlord has to come forth and show some other reason. And if it's, well, maybe, maybe not, the burden of proof is a preponderance of the evidence. That means it's more than 50%. They've got to prove that, yeah, that's potentially one of the reasons, but no, there was some other reason because of this. So they have to show to the court what the other reason is by their burden of proof. So again, very important provision that has to be taken into account. Question?
Does the landlord have to rebut in writing to the tenant?
Does the landlord have to rebut in writing to the tenant? No, the landlord does not. The statute doesn't say it has to be rebutted. It's a bigger burden. They have to show the court. They have to prove to the court in an eviction proceeding what their reason was for not renewing the lease or why they increased the rent or anything like that. So, again, very important provision. Here's another thing, and this gets into the rent gouging thing that we talked about. There's no definition of rent gouging other than I think it may play into this, which is if the landlord intends to renew a lease, so we'll renew the lease, and the rent increase is greater than 5%, or where the landlord decides not to renew the lease, the landlord must give written notice to the tenant that rent's going up by more than 5%, or I'm not going to renew your lease. And there are notice provisions. And the notice, that notice must be given under a certain amount in advance of the termination of the lease. And those time periods have expanded dramatically. If the tenant has occupied the premises for less than a year, or there is a lease that is less than a year, the landlord must give 30 days notice that rent's going up by more than 5%, or I'm not going to renew. If there's a 1-year lease, that's kind of our typical situation. If it's a 1-year lease, that 30-day provision does not apply. It's 60 days. So if the tenant has occupied the place, even if there hasn't been a written lease that we hope you all do, they're on a month-to-month lease, but they've stayed there for longer than a year on that month-to-month lease, or the lease is for a year up to 2 years, the notice must be 60 days. I'm not going to renew, or your rent's going up by more than 5%. If the tenant has occupied the premises for more than 2 years, so there's typical people, maybe they signed a lease that was a year lease, but they've stayed there for 5. The notice must be 90 days. 90-day notice for tenants who have occupied more than 2 years under any circumstances, or if the lease term is at least 2 years. I don't see that a lot, but there could be a lease, a 3-year lease or 2-year lease or whatever. The notice that rent's going up by more than 5%, or I'm not going to renew after this lease term, you must give at least 90 days notice. No notice, and the tenancy continues for the period of time until a written notice is given. So, got to be in writing, got to meet those time periods, or the lease will just continue on. So, make sure it all be in writing. Yes?
Mike, most of my students will sign a year's lease, but within the lease it does not have any provisions for renewal.
A lease that has no provision for a renewal, but there is a 1-year notice, yes.
Do they still have to do the same
If
thing?
the landlord intends not to renew the lease, they must give 60 days notice for a 1-year lease. Must give 60-day notice. Or if the rent is going up. Or the notice, or the lease will continue until they give the 60-day notice. Then they could give the notice. So again, very, very, very important. Another provision that is now codified that I believe was part of the common law before, and I've talked about this in our past landlord-tenant sessions, is the statute now says landlord has a duty to mitigate damages for tenants who breach leases by taking reasonable and customary actions to re-rent at fair market value or the current rate that the tenant had been paying, whichever is less. So, if the fair market, tenant's been paying $1,000 a month, but really the fair market rate is $750 a month, the landlord has the obligation to go out and get a $750 a month tenant. They have to take reasonable and customary steps. There's that term again. What's that mean? It means, I think in a lot of instances, most of us could agree what the reasonable steps are. What would a reasonable landlord or person in their shoes do? They'd go out and advertise it and try to get a new tenant in there. They can't not do that, and they better be in a position to prove they did that or attempted to do that, because if the landlord does not do that, it absolves the tenant of their responsibilities under the lease any further. Also, if the landlord then goes out and finds a new tenant for that, it's usually the situation. I've got to assume, I think that we kind of got to assume that landlords attempt to rent at reasonable market rates at the time. So that's a good gauge of what the market rate is. I mean, it could be different, but let's say that's what it is. So you really got to find somebody to rent it at the same price. If it proves that that rent is too high, good for you, landlord, for the first part of the lease, but tough on you if you go out and find somebody. But let's assume it's $1,000 a month. You got to go out and try and find and document your attempts to find a new rent. And if you do find someone, you got to sign a lease with them, or you got to execute the agreement. And what the statute then says is that that terminates the old lease. So the tenant is off the hook. My view is that that's really just a codification of what the old rule was, because as we talked about at the outset, the nature of the relationship is a contract anyway. That's contract law. It's an agreement between two parties where there's consideration, and we'll get into the weeds of the law on that. But as a part of contract law, if one side breaches, the other side has an obligation to mitigate. That's just the way it's always been. You got to try and cut your losses, in other words. But this now says, in this case, you got to cut your losses. And so we have that provision. So there, it's out there. Landlords can't just sit on their hands and say, hey, I'm supposed to be getting $1,000 a month for 6 more months, so I'm just going to sit back. You got to attempt to re-rent. If you don't, your ability to collect is going to get cut off. So behooves landlords, do it. Keep your records. If you showed it, keep a record of who you showed it to. Keep a record of what advertisement you put out there to do it, just so that you have records of that. Okay. Another provision, it's kind of part of the eviction stuff, but I'll segue into that, is in an eviction proceeding for rent due, so somebody owes rent, you go to evict them for the rent, and as a consequence, what landlords will frequently do is that they'll ask for a judgment against the tenant for the amount of rent that's due. And what it always used to be, because there were provisions in the lease for it, or because they could document expenses and things, they would sue for what rent was due, the late fees that were due, other expenses associated with it as well. Not anymore. What it says is, in an eviction proceeding for rent due, rent is defined solely as the charge for use and occupancy. It's the base rate. It's the base rent. That's what you can sue for. That is what you can recover. No fees. The statute says this. No fees, charges, or penalties may be sought in the special proceeding, the eviction proceeding, regardless of what the lease says. Because the leases used to say, these late fees are considered additional rent, or things like that. No more. You can sue to get that. Now, it doesn't cut off the landlord's right to sue, but you got to sue them separately for that. In the eviction proceeding, you get the rent. If you want to go ahead and sue for the additional fees and that sort of thing, you could go to small claims court and ask for those additional amounts. But as far as the special proceeding, it's just for an eviction to get the property back, and any rent, actual rent that was due at the time. Can't recover it. After signing the lease, but before occupancy, the landlord must offer the tenant the right to inspect the premises. And there's a requirement for a written agreement. Now the tenant can say, no problem, I'm not going to do it. And then fine, they don't have to do it. Landlords, you are crazy if you don't do this. Give the option, and before the tenant moves in, do a thorough inspection of the premises and note everything that potentially is wrong. I suggest tenants also inspect the property before you go in. The best thing is with the landlord, a burn on the countertop, a nick in the wall, this, that. Put it down. Write it down so that you're not responsible later on. But what the requirement is the landlord at least has to offer that now. Offer the inspection. Then there should be a written agreement under the statute attesting to the condition of the apartment. You cannot, landlords, charge tenants for noted exceptions that are listed on that as things that are wrong. So you can't sue them for the burn in the countertop because you checked on it ahead of time and it was in there. So you can't charge for the noted defects. Here's now an important thing. Landlords. You must do this. Landlord must notify the tenant to their right to an exit inspection. That notice must be given, the inspection would be between 1 and 2 weeks prior to the lease ending. Now, we all know damage can occur on move-out, but that's separate. The notice must be given that the landlord must notify the tenant of their right to a tenant inspection, an inspection of the premises, and the tenant's right to be present between 1 and 2 weeks prior to the end of the lease. Go through the place. Granted, there could be damage on move-out. There's no provision for that, but the tenant, if the tenant causes damage sometime after the inspection but before the move-out or at move-out, it would be the tenant's responsibility for damage that's caused. But at least I think generally it's the big things you can get picked up ahead of time, so the tenant has some knowledge of that. So make sure that you do that. Now let's get into all the big changes with evictions. Big changes. Landlords, huge changes. Make sure that you're aware of all of them. Going back to what I originally said, if you make a mistake, the time periods will strap you into that tenancy for 2 months more. So be really careful. And I'll give you some contrast to what it was before as to compare to what it is now. First of all, this was I think a given and understood provision before, but now it's actually in the law. And that is, landlords may only remove tenants by a special proceeding. You can't undertake your own personal eviction proceedings by throwing things out the door, because you can get big trouble now for that. So the statute comes right out and says you have to do an eviction proceeding to remove a tenant who will not move. You must. Failure to pay rent, you must. You can't shut off utilities. We always knew that that was the case. You can't do that. But now it says you cannot do this. You must undertake a eviction proceeding. So typically the grounds for removing someone is the failure to pay rent. So that's the scenario we're going to use. There are huge time differences. Remember what I said before that said you got to give them the tenant 5 days notice hey, we haven't received your rent yet by certified mail, that's kind of a separate provision. I would say to tenants and landlords out there, I could make a very good argument that that 5 days is an add-on, so you can add that to the other notice requirements. So you've got to, first of all, wait 5 days before you do anything. You can't start anything till you give the 5 days, and then give the 5-day the letter at the end of the 5 days. Been 5 days, you haven't paid it.
Is that 5 banking days?
Is that 5 banking days? It's 5 days. Okay? That didn't say business days. That said 5 banking days. There are other provisions that say business days, so it's 5 days. Okay, so add 5 days. We're starting out at the 5-day notice. There, again, is going to take, I've had some discussions with people who are doing evictions and things like that about that provision, because that 5 days is not in the section that deals with evictions. And I have represented, or I have talked to people who represent tenants, and their position is that 5 days is extra 5 days. And I can see that that's probably a very fair interpretation of it. Okay, so we're going on a failure to pay rent. So we've got the 5 days. So let's do a contrast. First of all, there was no, we're just assuming the 5 days is in there. It never was in before. So we're starting at day 5. But anyway, it used to be that before there was a precondition. Now there's 2 preconditions, 5 days plus another time period. There was a precondition to starting an eviction proceeding. And that was what I used to refer to as the first 72-hour notice. Before you could actually start an eviction proceeding, you had to serve on the tenant a 3-day notice, 72 hours, pay or get out, pay or vacate. You had to wait those 3 days before you could actually start the proceeding. That has been changed significantly. And I used to tell tenants this, is that these time periods are really short. It's 3 days, or they're going to start an eviction proceeding. Now, that 3-day notice is 14 days. So before you can start the eviction proceeding, you must give them the 14-day notice, pay or get out. And I will tell you, this provision about evictions went into effect on June 14, 2019. For anybody starting an eviction now, this applies. You've got to give them the demand to pay or get out. That's different than the 5-day notice, which says, hey, we haven't received your rent yet. Rent's due. So I call it the second notice. The 14-day notice is pay or get out. First notice, haven't gotten your 5-day, you haven't gotten your rent, it's been due. Okay? 14 days. Notice to pay. It must be served on the tenant if the tenant pays the rent in that first 5-day period or that 14-day period. Landlord must accept the rent and the lease continues. Now, what if you put in your notice that you haven't paid the late fees because it's now 10 days? Remember what we talked about before? You can only do an eviction for failure to pay rent, not late fees, not other fees. You can sue them in small claims court. They're still your tenant. Hi, see you in court. I'm going to sue you the $25 for the late fee that we had, but you can't use that as a condition for doing an eviction proceeding. Okay? So that once they pay the rent, if they tender the rent, we can't get fancy landlords. You can't say, yeah, I'm not going to take it. You haven't paid it, I'm not taking it. You can, if it's tendered to you, you must take it if it's paid. Okay? So, and if you then say, well, I never got paid, and the tenant comes in to court and says, I offered the payment, case dismissed, because you must accept the money. Okay? So that's it. So that is 3 days notice previously, now 14 days. Next provision is, the 5 days is up, the 14 days is up. How many days is that? 19 days. We're almost 3 weeks in. The eviction proceeding can then start. And it starts by serving a notice of petition and petition that the tenant has to be in court to answer the landlord's claim that the rent is due and payable and I want the property back. Because the tenant has exclusive use and occupancy of this premises. Landlord can't go in and except in an emergency to protect his or her interest in the property, a water leak or something is causing damage. Can't go in because exclusive use and occupancy of the apartment has been given up. What the eviction proceeding does is cut that exclusive use and occupancy and gives the property back to the landlord. Okay, so that's what the nature of the special proceeding is. It's called a summary proceeding for the recovery of real property. That's the formal term. So, contrast. Old law. After you did the 3-day notice, you served a petition on the tenant, and what it was you had to have a date that you were going to be in court. You check with the court; they have the date. Whatever that date is, you had to count back 5 days. Then you had to count back 12 days. That's a 7-day window. You could not serve the notice of petition and petition except in that 5 to 12-day window before you had to be in court. Okay? So if you served it 3 days before court date, case dismissed, start over again. If you served it 18 days before the court date, petition dismissed, you got to start over again. It's just in that 5 to 12-day window. Big changes. That 5 to 12-day window is now 10 to 17 days. So you got to find your court date, count back 10 days, count back 17 days, and during that window you have to serve the papers by a non-party, meaning the landlord can't serve it. Get a friend, somebody over 18, who can attest that they served the tenant with those papers. And then you'd be in court. So what time period are we talking about? We're talking about the 5-day letter initially, at least 14 days notice, and then it's 10 to 17 days before you're in court. So right now, we're at 29 days at the earliest that you can get in. The whole proceeding up to actually kicking the tenant out under the old law could be done as quick as 11. It didn't usually happen within that period of time, but it could be as quick as 11. We're already at 29, and we still got another time period to talk about. So you go to court. The landlord has to prove, I haven't gotten the rent. It's due and owing. I gave them the 5-day notice, because remember, when we initially talked about that first 5-day, hey, I haven't received the rent yet letter, is an affirmative defense in an eviction proceeding. If you didn't send it out, then you have to start over again. And right now we're talking about, we're already 19 days into this thing, and you get kicked out and you got to start it over again. The tenant can say I never got this letter. So landlords, you should put in your papers, on such and such a day, I gave them a copy of the letter attached as Exhibit A, saying, hey, I haven't received your letter. Attached is a copy of the certified letter receipt that it was sent out. Okay? Put it in your papers. Exhibit B now to those papers is, I gave the 14-day demand that was served on them. A copy of the 14-day demand is Exhibit B with the affidavit of service saying that it was served on them. So you're already at Exhibit B. And you go to court. Now, tenant has to come in and say, I did pay the rent, and try to prove that they did pay the rent, and the landlord's saying, I never received the rent. And we usually know how that goes. there's no proof that it was paid, and the landlord didn't have it, and the tenant can't show that it's paid, then the court would order an eviction. However, before we get there, there's another provision in the law that says, first of all, the answer that the tenant provides can be presented orally or in writing on the day in court. That used to be that you could put in the papers that you want their answer, depending on how soon it was served. I'm not going to get into the weeds of it, but you could demand that the answer be in writing ahead of time. This statute specifically says that that cannot be a requirement. They can come in and say, Judge, I did pay the rent. I don't have anything, it doesn't have to submit a formal answer in writing. It could come in, Judge, I paid the rent, here's a copy of the receipt, or whatever it is. But you can't not accept an answer that is presented the day of being in court. However, another provision, landlords, beware, that at the return date, which is the notice in the notice of petition says you got to be in court on a certain day, and we've already determined that it has to be between 10 and 17 days before you appear. Either party may request at least a 14-day adjournment. Tenant can come in, tenant can say, I'm trying to get an attorney to represent me in this issue. I'd like at least a 14-day adjournment. The court must grant that request. So that could be another 14 days to do that. I'm going to put that in I have a calculation of dates. I'm just going to put that as kind of supplement that somebody could come in and ask. A landlord could do the same thing. If, let's assume no adjournment was requested, or if there was, you wait another 14 days and you come in and there's no defense. If the court grants the eviction, the warrant, that's the thing the court issues, the warrant. It's not like an arrest warrant or anything. It's just the order of the court saying the property, we're severing the exclusive use and occupancy, and we're giving the property back to the landlord. The warrant, that order must state the earliest date that eviction can take, that execution can take place. Okay? Now we're getting into compare and contrast again. The old rule was that when the judge issued the warrant, the order, and this is the same, the landlord can't do their own eviction. What the landlord does is they takes the warrant to the sheriff, usually a sheriff. If towns now still have constables, you could use a town constable or a city marshal. We used to have them back in the eons ago when I first started practicing law, and we would go to the city marshal and hand them the papers, and the city marshal would go out and serve it. The enforcement officer, whoever it happens to be, would serve the warrant with a notice, which I referred to as the second 72-hour notice, because we had that first one initially, and it says, I'm going to be back, you have 72 hours to pack your stuff and get out, okay? It's now what should be affectionately referred to as the second 14-day notice. So the execution, first of all, can only be done at the earliest date set forth in the order. And when it's served, there must be at least 14 days notice that the eviction will take place, the execution of that eviction. So it's a 14-day notice initially, and a 14-day notice when the warrant gets served, at least 14 days. And the eviction may only occur between sunrise and sunset on a business day. That's where a business day comes into play. So I'm not sure that law enforcement officers were doing it anyway on a Saturday or Sunday, but now it says it can't be done. It's got to be on a business day. Here's another interesting part. Landlords, if payment for the rent is tendered at any time between the day of the initial 5-day notice, 5-day letter, and the actual execution by the law enforcement officer, the landlord must accept the rent. And again, you heard the definition of what rent is, the base rent. And the process ends. They can stay. Under this provision is if the rent is tendered or payment made with the court, so that's after the court has issued the execution, the court shall vacate the warrant unless the landlord can prove that the tenant withheld the rent in bad faith. And again, it's that heavy burden of proof beginning. If the landlord can show the tenant there was nothing wrong with this property. The tenant just withheld the rent because they were being a jerk. There was in bad faith withheld. Then the tenant has to prove that it was not in bad faith. It's the landlord has to prove that the withholding was in bad faith. Then they can get the court to say, no, eviction goes ahead. Question?
Strange and specific question. Are there any provisions for third-party payments for back rent in the law?
Are there any provisions for third-party payments? Under this provision, no, not that I'm aware of. It's whoever makes the payment.
Right. So the landlord can't say, I won't take this payment because a third party is paying.
Landlord, I would say the landlord would have a very difficult time because, let's face it, this whole business is get paid. And if the landlord's getting paid by whomever, they can't reject. I think a tender of payment on the tenant's behalf would also extinguish their right to pursue the eviction proceeding. So what that says, though, specifically in the statute, it says, even though the landlord has to accept the rent payment, it specifically says the landlord, or in this case the petitioner, can sue for any other monies due. This does not absolve their right to sue to get additional monies. So the landlord could, although the tenant gets to stay, and I know landlords are chewing the inside of their mouths about this, but they can then sue, say, small claims court for late fees and other things to collect. It's just not the basis to pursue an eviction proceeding. Now, here's another thing that is interesting that has changed in the law, and that is the court may stay, meaning stop, the issuance of the warrant or the actual execution if it's in the hands of the law enforcement officer. They may say, whoa, 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 whoa. The court can say, whoa, 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 whoa. The court can also say, whoa, 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 you can't collect amounts that are due at this stage under certain circumstances. The court can stay any of these things up to 1 year if, one, the premises are used for dwelling purposes. So we're already using that assumption. So this could apply in a commercial case too, but we're not even dealing with it. So, one, premises are used for a dwelling. Application is made in good faith by the tenant. Tenant makes an application to stay the enforcement of the eviction. Because the applicant, tenant, can't secure suitable premises within the neighborhood, and the applicant has made reasonable efforts to secure other premises, or that because of the execution, it would occasion extreme hardship to the applicant or the applicant's family. The statute then goes on to define what extreme hardship is. Considerations are ill health, by doing an eviction, it would significantly exacerbate an ongoing condition. Or here's going to be a big one, and that is the child's enrollment in a local school. So I think the provision would in essence allow them to get through the school year. And any other extenuating life circumstances affecting the ability to relocate and maintain the quality of life. A lot of definitions have to be court defined in that, but they could stay the execution. Now, in that analysis that the court is taking about significant exacerbation of a condition or extenuating life circumstances and things like that, the court also must consider any substantial hardship on the landlord. So that it gets put into the stew and decided, and the court can make the determination, do I grant a stay of the execution or do I not? Now, we go back to the applicant can't secure suitable premises within the neighborhood. Statute defines neighborhood. And the neighborhood is the same municipality, in essence, town, village that they're in, or, again, we get into the kid thing, the school district. If they can't find suitable housing within that school district, that's one of that's the definition of neighborhood. However, the stay may only continue if the court imposes, deposit requirements and things. So the court may say, well, I'll issue this stay, but you have to pay the ongoing rent that's due by the certain date, or make certain installments. Maybe say, okay, I'm going to issue a stay. Could be up to a year, but I'm going to issue a stay till the end of school this coming June or whatever. But you have to pay the ongoing rent, and you have to pay X number of dollars a month addition to cover what you already owe. You don't pay that, the stay is going to terminate, and the eviction can go ahead. So the court can impose these particular conditions, so it's as the court directs. That stay does not apply to a holdover tenant or to an objectionable tenant. So if a tenant's objectionable tenant is they're violating law or something, they're dealing drugs out of the house or something like that, that they can't go in and ask for a stay. Or for a tenant who actually is holding over, the term expired, there was no extensions, there was never an agreement between any extensions of anybody. If it's a holdover tenant, then they cannot go in and ask for that stay that the court awarded. Now, there's also provisions in a lease, lots of times. Tenant must do this, tenant must do that, all those sorts of things. If the reason for the eviction is because of a breach of a lease term, so it'd be something other than failure to pay rent, you're evicting them because there's some other term that you violated, the court shall grant a 30-day stay of the issuance of the warrant for the tenant to correct the breach. So if the tenant hasn't done what they're by obligation required to do, they in essence have 30 days to correct. And if they correct it within that period of time, eviction's over with. If they don't do it, then the eviction will go ahead. Question?
Yes. Can you define objectionable tenant?
Can you define objectionable tenant? It's somebody who is extremely violating the terms of a lease. They're violating law. For example, they're dealing drugs out of the apartment or things like that. Or objectionable tenant is, in essence, breaching lease terms, that they're causing damage to the property. Those sorts of things would be an objectionable tenant, that they've caused damage. So if they're causing damage, the court's not going to give them a stay so they can do more damage to the place. So those don't get that stay provision. Okay?
How about if they're...
I can't answer specific fact patterns because there's 10 million, and we could be there all day on trying to define what objectionable tenant is. It's big stuff. It's not, I don't like them, they're mean to me. Yes, that's objectionable, but it doesn't rise to the level. It's got to be serious objections. Okay, now we get to the situation where, what if the eviction is unlawful? In other words, the landlord is violating these particular terms. What does it constitute? Using or threatening to use force to evict someone, you don't pay your rent. I'm going to shut the water off. I am going to flick my high beams on your house at 2 o'clock in the morning until you move out of this place. That is an unlawful eviction. Engaging in a course, threatening or I'm going to kick your butt if you don't. Using or threatening to use force. Engaging in a course of conduct that interferes or intends to interfere or disturb an occupant's use or occupancy for the purpose of inducing them to leave. Threatening or engaging in any other conduct which is intended to prevent lawful occupancy and inducing the tenant to vacate, such as removing possessions, throwing them out the second-story window, changing locks, removing the door. Any of those things is an unlawful eviction. And landlords, it is a crime. It is a Class A misdemeanor to do that. It also could subject the tenant to the landlord to a civil penalty, get this, between $1,000 and $10,000 for each violation. So every time you threaten, every time you try to shut the water off, could be constituting a separate violation and subject you to that. So be wary, take that into account. I know this, going back to, I did my calculations. To do an eviction now, even with that, without that supplemental time of the 14 days, the earliest, assuming that 5 days preconditions the first 14-day notice, the earliest that the eviction can take place is 43 days. If you add the 14 extra days for an adjournment request when you go to court, 57 days. So you're talking about 2 months now compared to 11 days that the earliest it could have been. And so that 57 days extends, it could extend another 7 days, because if your notice of petition isn't served at the 10 days before, but 17 days before, it could add to that. So it is a huge change with repercussions very, very significant, because I'm saying that if you do something wrong and you go into court and have to start over again, you're talking at least 24 days before you'll be back in court, at least, if not more. So, word to the wise, do your due diligence, dot all your I's, cross all your T's. Tenants, know your rights. Go in, get legal counsel. There are legal providers, low-income legal providers, or if you don't qualify for those limits, get your own attorney to represent you to enforce your rights. There's some additional, again, tons more stuff. But let me just point out a couple of things, because the manufactured home issue can be big. Just a couple of things. I won't go into details of it, but if the owner of a manufactured home park wants to change the use of that park and stop, using it for housing purposes, significant changes. You got to give 2 years notice so you got to wait 2 years. You are required to pay a stipend of up to $15,000 to the mobile home owners, the owner of the mobile home, to move it, if it can be moved. Park owners must offer a minimum 1-year lease when somebody comes in. 90-day notice prior to the expiration of a lease. You have to give a written notice of another 1-year lease. Owners must disclose all fees, charges, assessments for lot rents. Can't put any increase on that without 90 days notice. Late charges are limited in a manufactured home park to anything after 10 days, not the 5 days that we talked about in regular homes. And I would say that that 5 days would apply that if the manufactured home owner owns the mobile home too. So you're in essence just the tenant of a building. Then I think the original rules go into place. This is for someone who actually owns the mobile home, the manufactured home that's in the park itself, and they have to get the heck out of there. It's at least 10 days notice of any late charge, and the delinquency payment is no more than 3% for manufactured home is the late fee. There's specific provisions dealing with those who are rent to own. So somebody moves into a manufactured home park under the circumstance that they're going to actually be buying that motor home from the mobile home from the manufactured park owner. There's certain rules regarding that. Just for people's information, rent increases are limited to 3% in a manufactured home park, except where the manufactured home park owner has provable increases in operating expenses, taxes, or capital improvements. And regardless of whether they have that proof or not, the maximum, even with that proof, the maximum is 6% increase without otherwise getting court approval. So they would have to get into court if they want to go greater than 6%. There's a ton to digest on this whole thing. What I tell people is, know what your rights and responsibilities are. Dot all your I's, cross all your T's. If you do that, everything will be fine. If not, there's going to be a whole mess of things that happen. I hope I've been able to at least touch on these in this short time that we've had. If people have any questions regarding that, I'd be glad to answer them. Otherwise, I would encourage you, information, because it's so soon that this happened, information is starting to get out there, but check. There are resources available. Things are going online now to help explain these sorts of things. Check out your rights. Those of you that, if any consumers out there, tenants that are out there, if there are any issues related to that, feel free to contact my office, the New York State Attorney General's office, to try to give you some guidance. We can't represent individuals, so we're prohibited from doing that. But if there is a systemic violation by landlords, there might be a landlord out there that is just completely disregarding the law. You run the risk. I talked about it already. There's pretty significant financial responsibilities with jurisdiction in the Attorney General's office to enforce provisions. So be very careful. Make sure you do what's right. I think in 90% or more of the cases, everybody's a good, conscientious landlord and tenant in trying to do what is right. Be wary of the ones that are then 10%, because you may be hearing from us. So again, contact us. Anybody have any questions right now on this?
Is this available online?
Is this available online? The law is available online. Just do a little bit of searching and you'll be able to find it. Do your general internet search and check on it.
What's the law called? Sorry.
What's that?
What's that law called?
What's that law called? I'm not it's like I said, when I originally started it, there's 15 different sections, and each section has a different name. Not everyone, but a bunch of them do. But think of, look up something like Tenant Security Act of 2019 or some derivation of that. I just put in a general Bing or Google search, just tenant law changes in New York 2019, and you're probably going to pick it up.
How would this, or will this be made available to regular tenants in housing complexes? I mean,
will this be made available to tenants? It depends, in regular housing complex. It depends on the landlord. If the landlord provides it, then it's going to be available. If the landlord doesn't provide it, the tenant can go out and find it.
can we request that the landlord make a copy of that, post it on a community bulletin?
Can tenants, like a tenant association or something, demand that the landlord post it? The tenants association can demand anything they want to demand, but there's no legal compulsion to do that sort of thing. Okay? Another question.
So regarding eviction, not all the evictions that come through my office deal with non-payment. It's mostly with behavior.
Behavior issues by tenants, behavior problems that come through.
You know, the 3-day notice to either pay or quit, we'll get the 3-day notice to either stop what you're doing or quit.
Yes.
So, you know, stop throwing a house party or vacate. Does that 3-day notice now change to a 14-day notice as well?
The question is there was a 3-day notice. I'm assuming there was a provision in the lease that says there's a 3-day notice to stop doing what you're doing, or I'm going to evict you. If there's no provision in the lease, the landlord would just go ahead and do their eviction proceeding, which is the 14-day initial notice. Well, in that case, it wouldn't necessarily be, because it's a breach of the lease provision. So you would probably just go ahead with your eviction proceeding, I presume, which is your 10 to 17 days. But you got to have pretty good grounds to be successful in showing that. The second 14-day notice, though, would be in effect to remove them. So it might be a little bit shorter in those circumstances, but you're still talking about a few weeks before an objectionable tenant can ultimately be removed. But also remember, there's that 30-day stay because of a breach of the lease. So the argument could be made that, hey, I get 30 days, we'll clean up our act, Judge, I promise we'll clean up our act within, and then it's going to be up to the judge to decide whether they get that 30-day provision and then toss it out. So it's kind of in a state of flux at that particular point. I would encourage landlords in that circumstance to seek their legal counsel's advice on what time periods kick in for them. I would also encourage tenants under those circumstances, first of all, follow the terms of your lease, okay? You're causing everybody a lot of problems if you don't follow the terms, not the least of which is you. And then go accordingly.
One other question. Did the legislature make any provision that landlords, especially those with substantial numbers of properties, are informed about this new law?
Did the legislature make provisions for landlords that they need to be aware of this law?
Yeah.
That's not what the legislature does. What the legislature does is they enact the law, and it's the incumbent on us as citizens to know what that law is. So they have to, landlords, that's a cost of doing business. Landlords have to stay aware of what laws are out there and have to abide by them. So the legislature only enacts the law, and then it applied. And to somewhat answer your question, in a lot of instances, gets back to the original part we talked about, a lot of instances there's usually some delay in the implementation of a new law. This law was enacted and affects immediately. So if somebody started an eviction proceeding on June 15th, 2019, not even aware that the law went into effect, that doesn't mean the law didn't go into effect. It still went into effect and applies to that particular provision. Okay? Thank you very much for attending. It's good to see bodies here. Those of you in TV land, join us. We are here at Cornell Cooperative Extension on the second Thursday of the month at 11 a.m. for our Consumer Issues program. I don't have off the top of my head right now exactly what next month's presentation is, but I'm sure it'll be very exciting. And those of you that have any questions, feel free to contact the Attorney General's office, so we'd be glad to help you with this or any other consumer-related topic. And again, those of you out there, please join us. Come in. The way we have this program set up is that for the first hour or so, in this case it's about an hour and a half because it's so pervasive and extensive, is that we talk about a consumer-related topic, and then after the taping is over with, then I'm still here for a little while afterwards, and I can answer anybody's question unrelated to the topic that they have, any consumer-related issue. So again, thank you all for attending. Hope we will see you again, and everyone have a good rest of your day.